Okay, everybody, let's get going. We're going to start with a quick bill hearing. House Bill 1298 prior auth. Senator Zucker.
Thank you very much, Mr. Chairman, colleagues. House Bill 1298 is the prior auth bill. What that is that any capital budget that had passed previously, if there's any modifications to amount changes or reallocations, needs to be done in a prior authorization bill that accompanies usually after the capital budget moves. This is that bill. So we'll make sure that it's amended correctly, and then we need to get it out in order for us to make those adjustments. And I'm happy to answer any questions.
So there are amendments coming?
There will be amendment. Yes, there will be amendments coming. I think council should already have a lot of them, but I want to just double check it.
These are just correction things mostly, right?
These are reallocations.
Yeah.
Yep.
It's correction
Correct.
from past.
Correct. It's not adding new money. It's
All right.
just that.
Move favorable.
So move favorable as amended.
Yes.
All those in favor?
Aye.
Opposed? Very good.
And then, Mr. Chairman.
Yes.
So, we'll take a look at this when it hits the floor. I'll be keeping a close eye on it. So I'll know based on the reprint where everybody is, and I can make floor amendments at that time, but it's important to get it moving. So appreciate it. Thank you, Mr. Chairman.
Thank you. All right. Philip? Did that ever reach you? That amendment?
No.
We have.
Okay.
Just a minute. Great. I'm going to bring Laura Addis from the Treasurer's Office up to the table, and also I believe we have somebody from the AG's office to help answer questions and go through.
Great. Got to get this one right.
Yeah, so
What's that? They're all right. That's right. We get them all right. All right.
So this is the bill related to the 529 program before you, Senate Bill 959. As introduced, the bill was abolishing the 529 board and transferring the operations of the programs under the state treasurer's office. You have amendments before you that have been worked on by the treasurer's office and the AGs. And so for the most part, the amendments are making some technical and clarifying changes. There is one main substantive change in that the amendments establish a claims and settlement process for participants in the prepaid college trust. So it sets up a process by which they can I guess make a claim and seek remedy with the trust for any issues with the administration of the trust in their experience. I don't know if I should maybe turn it over to Treasurer's office to kind of.
I think Philip did a nice job summarizing the work that the state treasurer's office has been doing with the Office of the Attorney General to mainly provide a settlement process for handling these claims so that account holders will not have to hire attorneys and go to court. This is an administrative process. It's an exchange of information, and then the treasurer would be making a final determination about what each account holder would be entitled to receive. I'm happy to help respond to any questions.
Senator Elfreth.
Thank you, Mr. Chair, and thank you for all the work you put into especially this amendment, because I think that is the constituents we've heard the most from are folks who have kids actively in college, and so they're the ones that have unpaid tuition bills from January, upcoming tuition bills in August, who are the most heartsick over the situation. So the bill goes into effect June 1st. I don't want to put you on the spot, but what can we tell our constituents in terms of the anticipated timeline for resolving the claims of those who are in the midst of their college careers?
So I spoke with the treasurer right before coming over, and there have been a few different iterations of the amendments while everyone's been kind of working on what it will look like. But with the amendments in front of you, the board's abolished June 1st and the treasurer assumes responsibility on June 1st. And then leading up to that, the treasurer is going to be trying to gain as much actuarial and legal information as he can so that on June 1st, he's prepared to start making a decision about what the earnings rate should be. And then the treasurer will need to announce what the decision will be. And then our office will have to make a decision about whether to outsource the administration of the claims process or try to do it in-house. The General Assembly has appropriated funds so that our office has latitude to try to do it in-house or to outsource. That's something that we will be thinking of before June 1st about how to stand up that process. And then the claims process in the amendments requires someone to file a claim by the end of the year if their claim arose due to this current issue with the disclosure statement. So, we would just kind of backing that up, like really the summer is when I think our office is going to be trying to get the claims process going and hopefully get payments out the door with priority given as practicable to people who have the need for the fall.
I really appreciate that. And obviously, we're not going to put that in legislation, but if you could try to resolve the claimants you have in front of you before the August tuition bills are due, that would be of tremendous help to our constituents. Thank you. Thank you, Mr. Chair.
Thank you. Sure. I'm just glancing at the process and trying to get my head around it. So I got a bunch of questions. So one is the expectation that the treasurer's office is going to set a policy or create regulations or something that's going to lay out how it's going to work beyond what's in the bill?
Well, the treasurer will make some kind of public announcement about what the earnings rate will be, but our office is required under the bill to establish procedures instead of regulations because regulations would be more delayed.
No, I'm with you.
Yeah, so
Okay.
administrative procedures, and then within 10 days of establishing procedures for how someone submits a claim, the treasurer is required to notify the account holders within 10 days of that, so that they would have quick sort of information about how to begin filing a claim with the treasurer, and then would sort of proceed from there.
And I'm trying to get my head around, will there be a formula that will just be applying math to
Yes.
how many years the people were in the program? Is that the way it works?
Yes, it will essentially, once the treasurer determines what the earnings rate will be, it's a math, it's running the numbers and applying it to an individual's account based on when they open the account.
So essentially, big picture, it will be a shrunken version of what was done by mistake. Is that a good way? Would they apply the earnings rate back? They intended to apply the earnings rate forward, but they applied it backwards. And that's the error, as I understand it.
Right, so the treasurer will be the sole fiduciary. So he will have the discretion to decide what earnings rate should be applied, looking back and also looking forward.
Okay, but the people at issue are the ones looking backward, but
Right,
in this amendment somewhere, it says the calculation of timing goes back to when you got in.
that would all be subject to the treasurer's discretion.
So the treasurer can say, we're only going to go back 5 years.
Well, so the treasurer could, what will likely happen is the treasurer will hear from the actuaries about what the trust can afford.
Right,
Because the bill says that the claims will have to be resolved within the assets of the trust.
right.
And so to your hypothetical, he could decide that the 6% could apply looking back to balances from 5 years ago forward. I
Well-
think he has a lot of discretion about how that would be
Well, that's what I'm
decided.
trying to get my head around in terms of trying to explain to people what this is. So he would have the discretion to say, we wouldn't go back very far, but that would allow us to give more money to each person. Whereas we might not do that. We might go to a lower interest rate, but we would go all the way back.
Right,
And that would be discretionary.
yes.
Gotcha. Okay. Second issue is you talked about being able to contract out. Obviously, this came about because of a bad contracting out experience. And so does the treasurer's office have knowledge of who you might contract out with that know how to do this?
To be honest, we haven't gotten there yet. I will say our office runs the state insurance program. So we have a tort claims unit that processes information in a similar manner. And because of the appropriation, we would have the ability to hire staff. So
That's the in-house option.
yes, and externally, we haven't started looking into who might be able to procure, enter into procurement with the state.
Okay. And sort of following up on Senator Elford's question, the timing here. So conceptually, what's the earliest that somebody might be able to settle?
I can't say for sure. Yeah, I know that the treasurer wants to do this as quickly as
No, I-
everyone else does, but
Well,
we just
but
don't
it
know.
can't be earlier than before we pass the bill. It can't be earlier than before the bill goes into effect.
Well, June 1st is when the responsibility transfers to the treasurer, so that would be the absolute earliest.
Is the goal and expectation along the lines of Senator Elford's question?
Is the goal or expectation to,
To get it done by the end of the summer, people paying fall tuition.
that is certainly our goal. However, there's a lot of things that need to happen with standing up the claims process, receiving information from the account holders, either hiring staff or outsourcing like through a procurement. So I know that this is the treasurer's priority.
Gotcha.
However, I don't know.
Well, we
Yeah.
appreciate you guys taking it on. Okay, thank you, Mr. Chairman.
Senator Bailey.
So I was just trying to clarify, we have people that definitely feel that they were not treated justly and that their children are in school right now. But for the people that whose children are seniors in high school, getting ready to graduate, what is the chance that the 529 program will be ready and able to disperse the funds for them for this coming year?
I guess I would say that the 529 program has been saying that they have always been able to pay tuition. It's just the additional costs associated with attending college. And so when the treasurer makes a determination about what rate will apply, that needs to be programmed into the IT setup that currently the intuition vendor runs. So once that's reprogrammed, then automatically all of the 31,000 account holders will have full access to their funds. But if you're seeking a rollover or a refund, and are, wanting a higher amount, you would need to file a claim and go through the settlement process. If you're satisfied with what you have, you wouldn't need to do that.
So okay, so that would be a little more clarification on my question. If they didn't want to roll over, they didn't want a refund.
Just want to stay
They
in the.
just wanted to stay in the plan and send their children for tuition, nothing else. Come this August when the bills are due, is the plan going to be able to provide the checks for them to go to school this fall.
I wouldn't want to say definitively, but I would expect the treasurer will have made a decision, and then it would be a question of how quickly the vendor can implement new business rules and automate whatever the calculation is.
How about people that are actually in the program right now whose children are in college? They got a disbursement this year. Is what they were dispersed, is that still gonna be able to be dispersed this coming fall for their next semester?
So I think, again, it depends on if someone wants to stay in the plan or seek a settlement for a higher amount.
That's correct.
Yeah.
Thank you. Thank you, Mr. Chair.
Just along those lines, what is the expectation about the continued existence of the plan? Is it just, it will continue?
Right. So
Will
the
new
door
people
will be
allowed
shut
in? Oh, okay.
June 1st of this year. The door is shut for new enrollments. So the legislation phases out the program, but there are people that have very young children that could presumably stay in the plan.
Senator?
Yeah, there's a provision on page 8. It says notwithstanding any other provision of law, this section provides the exclusive remedy for a claim against the assets of the fund. This is, I guess, a question for the Attorney General's office.
Thank you, sir.
I get it. The words are clear, but how does that relate to their rights under the contract?
The disclosure statement in the plan documents always contemplated that the trust assets.
Can you bring your mic over to you? There's one on your other side there.
Oh.
I'm
Thank
sorry. For the record, David Chase on Assistant Attorney General, and counsel to the treasurer. The plan documents have always said that claims against, be it the board, be it in the future, against the treasurer would only be claims against the trust assets.
Right.
So to that extent, they can't go beyond.
I get that, but I'm talking about if they don't like the proposed settlement. What legal position does it put the trust in, and what legal position does it put the claimant in? If they say, well, I don't like the settlement, I'm going to sue.
Well, we have defenses in sovereign immunity if we are sued, be it in contract or in tort. We don't believe that either would apply in this situation because the claims would be against the assets and not against the state, be against the assets of the trust. So there is judicial review if they are unhappy with the final decision of the state treasurer regarding a proposed settlement. And that would go to the circuit court. It would be very narrow. It would be based on the claim documents, the contract documents, and the plan documents.
That's the question I'm asking. So this doesn't in any way eliminate their ability to say, I don't like the settlement, I'm gonna go to court. All this says is if they win in court, the money has to come out of the trust and not out of the state.
Yes, but I want to be very clear that it would not be a lawsuit. It would be an appeal
Okay.
or a judicial review in the circuit court of the treasurer's final decision on the proposed settlement.
I mean, you're the lawyer and I'm not, so I get the words again, but what's the difference in standard of?
It's very deferential to the agency decision. So the court would,
Yes,
a very high standard for an account holder to meet in order to
Higher standard?
overturn
it is. It's a very narrow review that it would have to be arbitrary or capricious
I
to
see.
essentially be overturned.
And help me on that, because how does that work? I mean, the argument I think we'll get back is I got a contract. And are we saying this bill eviscerates the contract?
No, not at all. They still have rights within their contract in the defined benefit plan, in the trust. But as far as resolving the claims related to the past calculations, be them prospective, retrospective, that's what this process is designed to handle. Any claims related to that. It is our hope that once we establish this process, that we can resolve most, if not all, of the claims
Sure.
through this process. But if there was somebody that was not satisfied with it, they would have the right to file for judicial review of the treasurer's final decision.
But what happened to their right just to sue under the contract?
Again, the plan documents refer to it as a contract, but there are certain defenses in sovereign immunity, how far that the state has waived its immunity. This is just narrowing the immunity issues to essentially provide a claims process that considers both the plan holder interests and the trust's interest in resolving these issues. So it is just narrowed to this class of claims that we're talking about.
Okay, thank you.
Thank you, Mr. Chairman. Thank you all for you all being here. I want to go back to the timing issue. We spoke at the treasurer's office meeting with the actuary. Is the actuary engaged now, or does the actuary have to wait?
Yes, 529 has an actuary.
Okay, so the actuary is engaged now.
Yes.
All right, thank you.
Further questions? Senator Hellman.
Quick question. So in terms of the not subject to appeal, if they are unhappy with their settlement, is their only recourse going to court?
Their recourse would be to file the judicial review action, which is in the circuit court.
Okay, thank you.
Senator Bailey.
Thank you, Mr. Chairman. One more brief question. I appreciate everyone's time for this, but my question is about when we're talking about the prepaid college trust, and there's different forms of that, right? There's one that's just straight, and then there's a 529. Is the one that's not associated with the 529, is there any threat to that based on this? Is that money that those people just are getting paid straight? Is that at any risk of that? Yes. No. I mean, the prepaid, the prepaid, when you paid for college, instead of you going to a state school without the 529 part of it.
Senator, just to be clear, I think maybe both plans are 529. One is called investment and one is called prepaid.
And so both would be transferred to the responsibility of the treasurer. But the prepaid plan is the one in which there would be the settlement process. The investment plan is affected because the treasurer would take responsibility, but the financials and, the management of that plan is not impacted by the settlement process.
Thank you.
Any further questions? Everybody clear on what we're doing here? A lot of effort went into that. What's that? Yeah, well, look, I mean, it needs to be clear. I mean, I think a lot of effort's going into this, a lot of legal review. I know that we all care about making sure that we give a fair, as fair as possible as we can to the people who have been affected. I believe that well, you've got a question, Senator?
Can make a motion.
I mean, I think I think this is a pretty darn good effort to get there. Given all the constraints and legal issues. Okay, Senator.
Yeah, I want to move favorable. I'll move the amendments. Want to move the amendments.
Okay,
Second.
it's been moved and seconded for the amendments. All those in favor of the amendments, please raise your hand. Okay, that is unanimous.
Move favorable on the bill as amended.
Sure. Whoever wants to be on the bill. I was gonna say, who's on the bill? Well, everybody wants, whoever wants to be on it, whether you're on the bill or not, just raise your hand so we can be clear.
That's all B&T.
Everybody's going to be on it.
I'd like to make a comment.
All right, and did we take all those in favor? Let's do it again. All those in favor of the bill as amended. Okay, unanimous. All right, Senator Rosapep has a comment.
Yeah, I just want to agree with the chairman that I think appreciate everybody's work, appreciate the treasurer's willingness to take this on because it's a big undertaking and it's very important. And secondly, though, I'm really glad, I know that the treasurer proposed it. I'm glad everybody worked so hard to get this settlement language in the bill. It's great to fix the long-term problem, but we got people with short-term problems. And so putting together a strategy to take the assets of the trust to the extent they're available and try to make up for the damage that was done, I think is a really good step. And so I'm pleased that we got to this point.
Well said. Thank you very much.
Thank you.
Thank you.
All right, we've got some concurrences to go through. Isn't that what you said?
Just explaining what you're looking at there.
Yeah, let's do those for 15 minutes, but so we get, because we're gonna need to get out of here. Holy cow.
Yeah. Hold on.
Wow.
Didn't even be seen.
Yep. Um,
Right.
well, let's start with the McCray bill because, you know, that's what we always do.
Yeah.
It's the first one. It's
Yeah.
it's this one. Okay.
So this is the cross file to one that you all have, and the House amended it basically with who was the responsible party for purposes of the report that needed to be done. And it does match the action that you guys took on the House bill.
Okay. Move to concur. All those in favor? Opposed? Okay. 55.
Senate Bill 55 is the cross file, or Senate Bill 55 is the bill related to state tax portability, the federal filing. The House made a technical amendment to align the applicability of the bill with current law, which should be January 1, 2019. That's when portability first took effect.
Move to concur. All those in favor? Opposed? Okay.
And since you just concurred on that, that will now be identical to House Bill 179, which is in your possession.
So we will vote on that. All those in favor of House Bill 179? Opposed? Just for sake of clarity, should, as we keep going through all these, if you are opposed, it's going to be responsibility to raise your hand. All right, 114.
All right, Senate Bill 114, you do have a reprint on your desk, just because the amendments have lots of verbiage that you might want to read. This is the one that originally dealt with the constant yield tax rate, and instead, oh, okay, so
I didn't say, I don't see it.
just as background, that this is the one that basically modified how notice was given when the county was altering the tax rate. and basically got rid of the constant yield tax rate notification processes. So what the House did specifically in your reprint, the first thing on page 1, this is basically the property owner's Bill of Rights. And you can see that they added that a homeowner or property owner has the right to, as part of their assessment notice, saying that if their assessment has increased, the total amount of taxes owed may also increase. The other change is on bill page 7. This is what notification that the county would need to include on the property tax bill. Which is like the rate and giving information as to what the rate was last year, what the rate is this year. And even if the rates are the same, if your assessment goes up, an explanation that, or sorry, if the tax bill goes up, but the rates are the same, an explanation that that's because the assessment of your property went up and isn't a result of the rates. So if you want to read through that verbiage and make sure it's what you all want.
Thank goodness that language doesn't have to appear on the notice. What we just basically said, we let the department figure this out, right?
Yeah.
I mean, it's fine, but
Yeah, it's.
they made it more
additional-
complicated.
They did, yes.
But at the end of the day, that's not what the citizen is gonna say.
No.
Yeah, no, they are.
They are.
Not this exact language.
Hopefully not. It's what the language, the
Oh, I see.
content of,
I see.
it's the information that needs to
We'll
be
be able to
provided.
backfill the essence of what's here.
Yes,
Yeah,
yeah,
I do.
yes. Senator Alford.
Thank you, Mr. Chair. I don't want to mix and mingle two bills, but the addition of the front part of the amendment, I think is relevant to the other STEP bill we've been working on and haven't been able to find a solution to, the ag assessment bill. Because I think this notification of assessment is really important for all property owners. Erica, I'm wondering though, because in that case, it's a bit of a mix between real property and agricultural assessment. Does it say in here, and that's part of the confusion with that issue, is that people
Right.
don't know under what assessment they're being taxed. I'm not trying to kill two birds with one stone, but if I think there's a
You
lot
may-
of confusion around people's tax bills.
I just don't want to kill two birds.
I don't blame you.
Yeah, like, kind of just because that bill is only showing a portion of the bill of rights.
Okay.
I want to read.
I don't want to disrupt Mr. Chair, but I do think under what
Sure, minute.
assessment people are being taxed is
Take a
something that
minute.
should be on their tax bill.
Got a minute for you, Senator.
I need
Thank
other
you.
stuff to vote while I look at this.
I'm sorry.
So one of the other items that's not shown in this bill, that is part of the property owner's Bill of Rights, says the right to receive information concerning the calculation of the assessment and description of the property. I'm not for sure. The right to appeal. During an appeal hearing, the right to a review and explanation by the assessor of the items and values shown on the worksheet and report card, record card. I don't think we have record cards anymore. It's all electronic now.
I don't want to hold us up, and I think this addition of 0.4 on the first page is going to be helpful in that other issue. And that's partially helpful, and so I don't want to kill
Well, I
Keepers.
just read through the rest and those are the pertinent ones. It seems
Okay.
to be about the classification and assessment of a property.
But only upon appeal.
For the appeals one, not related to appealing, is just the right to receive information concerning the calculation of the assessment and description of the property,
Okay.
which to me kind of gets to what you're talking about.
But not necessarily on your tax bill itself.
Correct. This is just, yeah,
Okay.
correct.
Something we should think about and work on for next year, Mr. Chair. Thank you.
Brilliant. Okay, any other comments, questions about this bill? Move to concur? All those in favor? Aye, opposed? Okay. 148,
Senate Bill 148 is the VOCA bill, and the amendments on this bill puts the Senate bill in the same posture as HB 186, which this committee passed unanimously.
what was it? Number again? What? One,
It's the exact same as House Bill 186.
and that's downstairs, right?
They voted it this morning, so it's ready to move.
It's ready to move. Okay. Move to concur. And then we'll also see 186 on the floor then too. Which Senator Alfred did before. Okay. Did I say all those in favor? Opposed? Great. 274.
274 is pensions bills of the joint committee on nope, sorry. This is the bill about the non-vested accounts. No, sorry, it was like the first time. The joint committee on bill was doing some various administrative tasks. Yesterday, I believe you all had tacked on the amendment regarding the retroactive salary increases, creating the exemption for the one instance we're aware of where the employer actually made the employee and employer contributions. So that would be pensionable. Otherwise, retroactive salary increases are not pensionable. In addition to the other provisions of the bill as passed, which were not amended.
So we can form the House bill to this bill?
Yes, you've already done this to the House bill, so they're doing it to the Senate bill, so you would concur and they would match.
Okay.
Consistent with what-
Concur, all those in favor? Opposed? Okay. 283.
So Senate Bill 283 is the bill that would create the Mental Health Workforce Development Fund. The bill required MHCC to do a workforce analysis. And in the House version, the commission had requested the date be pushed back from December of 2023 to October of 24. So they amended the Senate bill to do that. That's what the.
That's
House
it?
amendment- Yep, that's it. And that was at the
Concur?
request, that was at the request of the Healthcare Commission.
All those in favor? Opposed? Okay,
And then consistent with that concurrence, you have House Bill 418, which is currently in the same version as the Senate bill you just concurred to.
okay. Move approval of House Bill 418.
Second.
All's in favor? Opposed? Okay, who had that last time? Who had that bill on the floor? Are we second? That sounds right.
No, B&T was primary.
Somebody fess up. We'll track you down. I'm telling you. No, we'll get somebody. We'll get the person who had it last time.
Senate Bill 283.
Who was it? I'm glad you took so much interest in the bill.
You get sponsored?
I know. Well, I would have thought I would have given it to you just because health, just, yeah. All right. So let that be written. 328.
328, this is, you also have the crossfire, which you already voted on the House bill. This is identical with the exception of the effective date. It moves it from October to July, which is how you guys voted on the House bill.
Move to concur. All those in favor? Opposed? Okay. 333.
All righty, Senate Bill 333, and then we have the House bill as well, so I'll do that second. This is the Rise Zone bill. You guys, the differences are with one aspect of the bill. You guys, as you sent over the Senate bill, you struck the limitation on the number of rise zones that could be established in a single zone or municipal corporation. They put that limitation back in.
Oh, wait a minute. They put the two back in?
Yep.
We're not concurrent to that. Huh?
It's two.
They made it two.
No,
We
no.
wanted three.
Current law is two.
I know, but we didn't, what we passed?
You left it unlimited.
Unlimited. Yeah, well, we certainly didn't want it two.
Okay.
Yeah, I thought we moved it up to three, but whatever it was, I knew it wasn't two.
Yep.
Yeah. Now we.
Oh my gosh. Yes, three. My apologies.
Two and a half.
It has to be at least three. Where where it doesn't work for some of the things that we've got on the ground.
Any jurisdiction hasn't had more than
I don't like the fact that Corbin's right, but aside from that,
I was the floor leader on it. And I think we do have at least one in my mind jurisdiction that is the potential and needs
Yeah, yeah.
more than three.
yeah, we know. Yep, we got it. Huh? I know, we're gonna leave. This is the last one. All right, so we will not concur.
Okay, so we'll deal with who your conferees would be when you get back.
Yes,
Okay, great.
okay. Executive nom people, off we go. Okay. Let's get started again. We're on 350.
Will you,
Good bill.
we haven't named conferees, but we can do that later.
Okay.
however you
Where
want.
we are on Hayes. Yes. Alfred did the bill, right? Alfred, Quarterman was on this too, right? Yeah. The rise stuff,
Alfred is chair.
yeah. You didn't like the bill? Oh, you were not helpful. Did any of you guys vote for it? Huh?
Yeah.
Not on the, it's conference committee.
There's a lot of interest in this bill.
Were any of the four of you, did any four of you vote for the bill? All right, well, then you're on the conference committee. Jeez. Why are you always causing an extra issue? Yeah. All right, and Zucker.
Alfred, Quarterman and Zucker.
All right, now we're on to 350.
Okay, Senate Bill 350, this is the childcare bill where you guys had it as just an MSD couldn't alter basically the various benefits and income thresholds for the childcare subsidy, scholarship program unless they gave you notice. There is some verbiage in the House amendments that just kind of clarify, they don't change the substance of it. But they do add, when you guys had the limitation, it applied to the co-payment levels, the reimbursement rates and income eligibility requirements, but not the freezing of the program. So they added that the notice that they can't freeze it without the notice as well. Then they expanded.
Oh, sorry. Can't freeze it. You lost me.
So there's basically 4 ways that MSDE could limit the program.
Okay,
One would be they could potentially increase co-payment levels. They could reduce the reimbursement rates that they, the scholarship value. They could reduce the income eligibility requirements.
okay.
They could also just implement a freeze and not take any new applicants.
I see.
So this adds that as one of the 4 things that they can't do without giving you notice.
Oh, that's it?
That's it.
Move to concur?
Second.
All those in favor? Okay, opposed? St. Mary's. Ugh. What are we doing with that?
So this one, what number is that? 350, 457.
It's the local bond.
Yep, it changes the total amount that they can authorize from 41 million as you guys passed it to 56 million.
Holy cow, what's going on down there? It is. Wow. You okay with this, Senator Bailey? All those in favor? Opposed? Okay. 469.
469 is, this is the one that you guys turned into a task force. Their amendments are adding a couple of people to the task force membership, as well as increasing, basically specifying what some of the study requirements would be, expanded what they needed to study. Correct, they did change it. Yes, correct. Thank you.
Seems reasonable. Move to concur. All those in favor? Okay, now what's Charles County doing?
Charles County, this was the local optional property tax credit that had the income limit. Okay.
What? What's different about it? Anything?
So we had the 250 threshold here in the Senate. The House wanted a 150 threshold. We're late in the session, even though we passed our bill very early in the session. We're too close to have it die.
Yep.
Too important. So.
Got it. All's in favor?
Aye.
Opposed? Okay. This one. All right, 537.
Senate Bill 537 is the gaming video lottery operations license renewal bill. As introduced, this bill did not include all of the amendments as we received on House Bill 217. However, the House conformed Senate Bill 537 to House Bill 217, making it 1% of the fee
So this is,
at that 1% rate.
so this is a dramatic change from what we passed. I think this whole issue needs a bunch of work and it's complicated. So I'm gonna move not to concur. All those in favor? Opposed? Me, Nancy. Who wants things? Who likes gaming? You want to try? Senator Solling. Got it?
But yeah, so that was,
No.
Tim's got it, but I did get it. I got it.
Okay, good. All right. And I did vote right on that. Did I vote, I take the vote on that?
Mhm.
Okay, good. Okay, so 556, before we get started on that, we have the, what is it, 701? House bill?
Did you want to do that now or?
Well, I just want to make sure I understand what the whole package is I'm doing it. The 701 in our possession,
Yes,
House Bill 701.
yes.
And is that in the correct position?
My understanding is yes.
So is it what they sent over?
Yes, I don't have any amendments for House Bill 701.
Okay. All right, then let's start with 556.
Okay, 556, this bill passed out of the Senate. It would give the Community Health Resources Commission the same compensation authority for unique skills and unique functions for their staff that the other two health commissions have. The House had added an amendment to shore up their special funding for the next 5 years. And so what the House amendments do is they direct $8 million a year for fiscal 25 through 29 from the Cigarette Restitution Fund to the CHRC fund to ensure their base program is set for those 5 years operationally.
Okay. And just so everyone understands what's going on here, if it's a little unusual circumstance, we're going to pass these two bills that were both, they were cross files. As you heard, the piece that was added to this, the Senate bill that they have that I want to move to concur to, was to give a longer term funding sustainability to the Community Health Resources Commission. The next bill, we're going to make the House made some changes to, and then we'll vote to approve that also. But the interesting thing is we're going to keep these two bills different and pass both of the bills. And the reason we have to do that is to avoid more than one subject matter problem. But we get all the stuff we need to accomplish with the two bills.
The changes made, so House Bill 701 and House Bill 556 both came in identical to give CHRC the authority. In House Bill 701, they also extended compensation authority for the comptroller, treasurer, and attorney general's offices. we don't have confirmation, but to avoid even the possibility of a single subject, the Senate bill will have, both bills will have the CHRC compensation authority. The Senate bill will be CHRC compensation authority and the funding mechanism. The House bill will be CHRC comptroller, treasurer, AG compensation authority. So one bill will be CHRC operations and funding. One bill will be compensation authority.
So move to concur first on the Senate bill. All in favor? And now taking up House Bill 701 as described. All those in favor? Opposed? Okay. 773.
773, this was a procurement bill. This is the bill dealing with the liquidated damages clause. The House made an amendment, which the first change would be that the Board of Public Works, in developing its model policy, shall do so in consultation with the Procurement Improvement Council. And then the second change would be at the end of the bill. The Senate had struck language and substituted language about documenting when liquidated damages are not included or not exercised. And instead, the House struck that language and added substitute language that requires the head of the unit to approve not including liquidated damages. And then for procurements of 5 million or more, if a unit decides not to pursue liquidated damages for an associated breach, the unit shall obtain approval of the head of the unit and then maintain documentation on the reason it decided not to pursue liquidated damages. Oh, sorry. No, there is no House bill. It was not cross-filed. This is only Senate Bill 773.
Did everybody get those? All those changes? I think we better do them real quick again.
Okay.
Just
So-
briefly,
Yeah, the first change is in developing the model policy. BPW is required to consult with the Procurement Improvement Council.
okay, next.
And then the second one, it's pretty close to what you all have passed, but under the House amendments, the head of a procurement unit needs to approve not including a liquidated damages clause. And then
Has to approve, the head of the union has to approve it. If they don't do it.
has to approve the absence of
And
liquidated
how was
damages.
that different from what we had?
You all had just required maintaining documentation if a liquidated damages clause was not included.
I'm okay with that.
And then the second piece is for procurements of 5 million or more. Presumably when there is a liquidated damages clause, if there's a breach that could trigger that clause and the clause is not exercised, again, the head of the unit needs to approve not exercising the clause. And then 2, they need to maintain documentation on the reasons why they're not pursuing liquidated damages.
Above 5, yeah. I think that's fine. Everybody got it now? I do at least. All right, all those in favor? Opposed? That was a motion to concur. All right. 826.
All right, House Bill 826, you all, sorry, Senate Bill 826 is a cross-file to House Bill that is still in your possession, but it is on the vote list for today. This deals with the
What's the number on that?
the House Bill?
Yeah.
897.
897,
Yeah.
okay. 897 is the cross. House bill.
So this is the bill that deals with if you're a homeowner and you have the homeowner's property tax credit. Normally you'd have to apply every single year for it. This is the one that says if your income is only from Social Security, pension, or annuity, that you can do it every 3 years, but in the intervening 2, as you guys passed it, a certification. What the House did is still maintain that, but they gave a little more teeth to what that certification needs to look like, as well as added a couple of additional eligibility criteria to be able to do this intervening report. So let's see, they need to submit the application only in the first year. And then every third year thereafter. So
That's what we do,
that's
right?
what you do. They
Okay.
just changed that language but it's still the same thing. And then for the intervening 2 years to be eligible for it, the homeowner needs to submit to the department either a certification that the homeowner resided in the dwelling for at least 6 months in the prior calendar year. The homeowner continued to have income only from those 3 things in the prior calendar year. And the individuals living in that household did not change in the prior calendar year. Or if they can't show those, then they would still need to do the regular full-blown
And
application.
We didn't require anything in the
Correct.
intervening years.
Correct. Well, no, you required a certification,
And what was
just
in the
that the certification that you guys required that the gross income information in the big application has not changed.
What's that? Senator?
One-time submission?
The big application would be
Yes.
every 3 years. In the
Yes,
2
every 3
intervening
years.
years, under your bill, they had to submit a certification that their income had not changed.
And the House bill adds 3 or 4 criteria. that they have to-
Correct.
They have to, but I don't know. I think they should be easy on people. All right, let's motion not to concur.
Second.
All those in favor? Opposed? All right, Senator Rosapap,
No, I shouldn't have said anything.
Senator McKay, and Senator McKay. Why do I keep doing that?
McCray?
What is going on with that? McCray. Why did we let him into the Senate? I don't know. And Senator Bailey. Okay. All right. Oh. Why is this on the?
This
concur?
is the House
Post
Bill one. They've
receipt.
already, yes, they are asking you guys to recede or not recede.
That would be a big fat no.
Same conferees, I presume.
Yeah, same conference.
Okay. Put to vote on that.
Senate Bill 333. Yeah, when you were out of the room, I put you on something. Careful. The rise and just, go along. Give me a minute here. Let's pull up House Bill 584. Yes.
House Bill 584 permanently extends the state income tax credit for eligible food donations by qualified farms. The farmers get 100% of the value of the food donation up to a $5,000 limit. The fiscal impact on that bill was $100,000.
Any questions? All those in favor? Okay. Senator Jennings. What kind of compost? Oh, my gosh. Okay, House Bill 735.
735. So this is an annual bill that you guys deal with, having to do with the University System of Maryland's authority to issue academic revenue bonds. So this one comes in with $30 million for, academic facilities bonds to do various facility renewal projects, as well as a specific project, a $5 million specifically for College Park, 25 million for everybody else. What the House did is they also added a provision that changes what happens to the proceeds when a university sells property. Specific to, this is one is specific to a non-residential campus. What's going on here is normally if a campus sells property, the proceeds of that would go towards other facility renewal or other campus projects. This one, because it's phrased as a non-residential campus, and this is getting at the University of Maryland Global Campus, because they don't really have other facilities when they sell property. What this bill is doing is allowing them to use the proceeds of that for operating costs.
Questions?
Chairman.
Yes.
Sorry. I lost focus briefly. I missed the beginning of it. I know.
735?
Is this? I can't find it on the list here.
735.
735. Okay, that helps. Okay, so this is without amendments. This is as it came in.
Yes.
As it came in from the House. Yes.
And the change from the House.
What the House did is they changed where proceeds from the sale of
Right.
property for a non-residential
Right,
campus,
UMC.
UMGC, but it's also, could be like Hagerstown or, some of the other smaller ones.
Okay.
The proceeds can be used for operating expenses as opposed to just putting them back into facilities at the.
But I thought that was the
university.
original bill.
No, the original bill was only the bonding authority of $30 million.
Oh, I see. This is putting that provision in the bonding bill.
Correct.
Got it. I now understand. Thank you.
And so, but does this put us out of whack with our bills?
This isn't cross-filed.
Right. Okay. That's what I thought. All right. All those in favor? Opposed? Zucker. Okay. 707.
House Bill 707 is the taxpayer advocate bill. This committee passed the exact same bill in the exact same posture earlier. That was Senate Bill 660.
All those in favor? Opposed? I think Edelman had that, right? You did? Oh, maybe you did. He could have. He doesn't work for them anymore.
Oh, okay.
Maybe he doesn't want to.
It's a mystery.
It's a mystery.
He made it. If it happened on April 1st.
I just don't have it in the system.
Okay, so whoever it is, you're gonna do it. Okay.
Unemployment insurance fund.
I know we're antsy out there. Just a second. We're gonna get out of here early.
I know.
Yes.
You don't mind, can we look at HB 5?
Is it on here?
Yes.
5, 4, 3.
The small.
Okay.
procurement.
All right.
House Bill 543 increases the small procurement thresholds. It's currently 50,000, so for most small procurements, we go to 100,000, and then there's some other ones that have different adjustments.
Yes.
The Senate bill is 923. First bill.
Senate Bill 923 is the Green Space Equity Program, the establishment of that program. This bill provides grants to eligible applicants to enhance the public health and livability of overburdened communities and underserved communities by implementing projects to preserve green space. The bill transfers funding from existing funds, and for FY 25, it's $5 million, FY 26 is $7 million, and FY 27, $10 million. The existing funds come from the the program Open Space.
Okay,
And both Senate Bill 923 and House Bill 503 are exactly the same. The Senate added amendments to Senate Bill 923 to make it consistent with House Bill 503 as it passed the House.
okay, these bills now on a consent agenda.
All right.
The vice chair has been asking for more consent agendas. So both bills, the one is amended, and the one as it is, and they both end up being the same way. All those in favor?
Aye.
Opposed?
I don't know that the Senate President allows us to put amended bills on a consent calendar.
No, I mean, it's not a
We're
real consent.
secondary.
No. That was That was just this consent. It was consent for here.
More fun.
I'm trying to make it more fun. It's tough. It is very tough. Is the 418, did we do that one? Is that the one that?
We did
Senator
that one, yeah.
McRae? Huh?
Yeah, we did that one with the concurrence.
We already got it.
Yes. That was favorable.
You want to do the Montgomery County one?
House Bill.
Oh, I see. Okay, let's do it.
We didn't do it.
House Bill 783, this is Washington Suburban Sanitary Commission bill. It's renewing their minority business enterprise procurement preference program, and then making various changes and administrative streamlining based on the recent disparity study.
Okay,
We have letters from both Montgomery and Prince George's.
okay. Move approval. All those in favor? Senator Jackson. Okay, let's finish up and first off, just a question. Did the last one, 1288, didn't we do that already? The Senate bill? Would we have that?
We did not.
We don't have a Senate bill on that?
We do.
I thought so.
Senate Bill 1288.
No. House bill.
I'm sorry, House Bill 1288. Is the
But-
video,
Did we already pass the Senate bill?
we did not.
We didn't.
I don't think so, unless we did it yesterday. I have it here. No, we did not.
We did it or not?
We did not do it.
We did not do it.
House
Okay,
Bill 1288 exempts an applicant for a video lottery employee license from disqualifications for convictions, active parole or probation within the prior 7 years or current prosecution for any crimes involving moral turpitude if the conviction was a nonviolent misdemeanor.
I do too. How are we feeling about this? Anybody have any thoughts about this, Bill? Is this in the same position as the Senate bill that we haven't taken action on?
We did not have a Senate bill.
Oh, there was no.
It's only a House bill.
Oh, okay. You did say that, but she said that we had a Senate bill. Did I not hear that one? It's true. It's true. You were wrong earlier. All right, all those in favor? Opposed? Okay, all right, last thing we're gonna do. Last thing we're gonna do is we're gonna do any delegation bills in here, and it looks like they're all St. Mary's. Because I don't know why you're putting out all these delegation bills, 887. Eight eight seven.
Yes. Okay, so House Bill 887, not a cross file. It updates the local laws for St. Mary's County to require their Metropolitan Commission to obtain approval from the commissioners for any loan application if they're seeking to incur the debt of the county.
Okay, got a letter.
Yep.
All in favor? Aye, opposed? Excellent. There was another one, wasn't there?
247.
247, yeah.
All right, House Bill 247, again, not a cross file. It extends the termination date for St. Mary's County's authority to impose a transfer tax by an additional 4 years through October 1, 2028.
Okay, letter, all those in favor? Aye, opposed? All right, that is it for today. We still have a few more on this list. We already have a list developed for tomorrow. Yes.
Our local bill tomorrow will sit in House Bill 529 and Sandy Rose. It's not on that list yet.
Okay,
It's tomorrow and it's got a letter.
okay, who's got it?
Hi.
It's in good shape?
Yes. This bill codifies existing preferences and practice and sets the language at a maximum. This is the gaming video lottery terminal local impact grant. The bill had amendments, though I did not distribute the amendments yet. But the
Sent to
Sim- oh, go ahead.
Let's do it tomorrow. Let's do it tomorrow. Okay, 1 second. We're checking on one thing quick. All right, we can wait for that tomorrow. All right. Thank you all. Oh, tomorrow.